Okay, so I started the recording. So this is the Title 101 training, and it's particular to the Title Coordinator role. The agenda for today, we are going to talk about the system of recording, conveyances, liens, bankruptcy, fiduciary, transaction rules, and then by the end of it, we're all going to be title experts. So jumping right into the recording system. The recording system gives us proof of title. It proves ownership for a particular property. It is public record, so it's accessible to the public. Anyone can look up public record and see who owns a property, see what encumbrances are on that property. All the states have enacted have a recording act that they enforce, and there are three primary objectives for the act. So number one is to secure the prompt recordation of all conveyances. And that is giving right to the purchaser, who is first to record his or her interest. Number two is to protect subsequent purchasers against secret or unknown conveyances in agreements. And then the last one is to preserve an accessible history of each title so that anyone that needs the information can ascertain it to whom the title is vested and what encumbrances were against the property. And this is the pillar of our American recording system. The chain of title is the chronological order of transfer of ownership for a specific parcel of land. What is real property? Real property is the land and any improvements. What's an improvement?
The house.
A house.
Garage.
Sheds. Yep, sheds. I put the pretty palm tree on there because trees are part of the property. Pool would be an improvement. Yep. Anything that is included in the land, so any bushes, rock walls that are part of the property, the house, the sheds.
So large landscaping?
What's that?
Like landscaping, like the larger?
Yeah, yep. Large boulders, the rocks, sand. Who can tell me what personal property is?
The contents of the house?
Mm-hmm.
Car?
Yep. My water bottle.
Yeah, pretty much anything that's
Chris's shirt.
Anything not affixed to the land?
Personal property is everything else. So real property is the land and the home and all the improvements on the land. Personal property is everything else: this table, the chair, cars. Do we ever deal with personal property here?
Mobile home.
Mm-hmm. Yes. If the mobile home is not affixed to the property by a permanent foundation, it is considered personal property. It's taxed as personal property. It's not included with the land.
So once you sign the affixation affidavit, that becomes land improvement?
Well, that is proof that it has been affixed, but you actually have to physically affix it. So once it is affixed, you have to have a permanent foundation, affix it to the property, go through the assessment records to have it taxed as real property. And then you'll see the affixation affidavit executed and recorded. Okay, what is a deed?
That's what conveys the property to the property.
Yep, that's what conveys the property. Is there any other instruments that can convey title besides a deed?
A will or a will or like a trust agreement if somebody had an heirship to trust.
Yep, a will, probate documents, affidavit of heirship. Sometimes a divorce decree can convey title, or a death certificate. I'm going to go over 3 of the most common deeds that we see here. The warranty deed. This contains covenants known as a guarantee that's made by the grantor to the grantee. So the grantor is signing the deed and they say, I guarantee that I have good title. I have no defects, I have no outstanding interest, I have no outstanding mortgages or liens or unpaid taxes. I have authority to sign this deed and I'm going to defend that. So the seller is guaranteeing to the buyer that they have good title.
So is it basically the seller's choice what kind of deed they want? Because sometimes on purchases it'll still be a quitclaim deed. You know what I mean?
Yeah, so it depends on the state. So Massachusetts does quitclaim deeds.
Okay.
They don't recognize the warranty deeds. So you'll see a quitclaim deed, and we'll go over what a quitclaim is. But you're going to, for a purchase transaction, you want a warranty deed because you're doing a full search of the property. If it's, based on the state, say it's Rhode Island, you're doing 50 years. So we're searching 50 years. We are looking at the past 50 years of the chain of title and making sure there are no outstanding interests that haven't been cured. So by them signing the warranty deed, we already have the proof to back it up that they don't have any outstanding interests, and that's the type of deed that the buyer is going to want to get. The special warranty deed is the same as a warranty deed, except that the grantor is only making those guarantees as to when they held the property. So they're not going to make any guarantees for prior owners, but they're going to make guarantees that since I held title, I know that I don't have any outstanding interest or liens on the property. So the transactions that you would see a special warranty deed is from a lender when they foreclose on the property. They only get the property for a certain amount of time. So they foreclose on the property. They're not going to go and get an owner's policy to search back and have those guarantees and have an owner's policy to rely on to be able to make those guarantees. They're only foreclosing on the property. They have it now and they only know what happened with the title from when they foreclosed to when they're selling it. So they're only making the guarantee as to when they held the property. Does that make sense?
Mm-hmm.
Okay. So the quitclaim deed makes no warranties. The seller is conveying whatever interest they may have. They may not have anything, right? So sometimes we see that a non-titled spouse will convey their interest, their marital interest. They may not actually have a fee simple interest. They're conveying whatever they have, or just to clear up title records to disclaim any interest that they have. We see a lot of quitclaim deeds when it's adding a spouse or removing a spouse, because they don't need to make any guarantees to each other. It's not an insured transaction. They're not paying money to obtain the property, so there's no warranties that they need to make. Okay, so when we are, for the majority of our transactions, we're adding a spouse, removing a spouse. That's typically what is done here. So you'll see the quitclaim deed. Okay, so an owner of real property obtains a bundle of rights. So there are 5 bundle of rights. Did anyone get that bonus question?
Nope.
All right, so the 5 bundle of rights. You have possession. You can possess the property. You can live there. You can go in the home and live there. You have control. You can paint the walls blue. You have exclusion. You can tell someone to leave your property. Enjoyment. You can enjoy your property. You can have a barbecue in your backyard. And disposition is disposing of the property. You can sell it. So those are the 5 rights that you have. So while you own the property, you have all those rights. There are some instances where an owner will give up some of those rights to somebody else. Any ideas when that would be?
Kind of like planned unit development, because you have to follow like restrictions that they've set.
Kind of,
Oh.
yeah. Mm-hmm.
People are
Does
landlords,
anybody, what's that?
landlords?
Yep. So if anyone leases or rents an apartment or a condo, they can possess it. They don't really have as much control. You have exclusion. You can tell people to leave. You can enjoy your property. You cannot dispose of the property. So the landlord retains the disposition, most of the control. You can't just go in there and redo the kitchen. But you can possess it. You have exclusion and you have enjoyment. Okay. There are also ancillary rights that you can obtain in your deed, and that those include access rights, mineral rights. There are surface rights, some water rights, subsurface rights, and limited air rights. Okay.
What does that limit their rights? Is that New York or something?
Well, you have limited space. So when the convention center on that airwalk, right? They had to come to, it goes to the convention center to, is it the Dunk?
Oh,
Yeah.
that whole, like,
Right. So they had to come into agreement to build that. So the property owners have that limited airspace.
And
So-
what about like mineral rights? Never really understood that.
Yeah. So if your property has minerals that, you know, gases, minerals, any of that, most of those we see in Pennsylvania. There are, and then subsequent with that, you'll see leases. So most of the sellers will retain those rights. You'll see that a lot in deeds, and sometimes they won't. And you'll see lease agreements where they give the right to someone to come in and take the minerals from the property in exchange for, you know, some minimal monetary value. Interest. So there are different interests that you can hold a property. The greatest estate where one can have in real property that includes the full bundle of rights and some of the ancillary rights that we spoke about is the fee simple absolute. So the majority of our transactions, our property owners have fee simple title to the property. We also see life estates, and there are different kinds of life estates. But for the most part, you're going to see a life estate where one person has an interest to be able to live in the property for as long as they live. So what we call that interest, that person's the life tenant. They can live there for their life. Most of the time it is based on their lifetime. They can convey their life estate to somebody else, and then that new person has a right to live in that property for as long as the original person's life. So if Leanne has a life estate in a property and I convey my life estate to Michelle, Michelle can live in that property for as long as I live. So it's based on somebody else's life. You don't see that a lot. The majority of the instances that we see is a parent who wants to do some estate planning. They want to make sure that their children get the property upon their death. So they'll convey title to their children and retain a life estate in themselves. The life tenant must sign any documentation. So for our transaction, they have to join in the mortgage. If the children were deeding the property, they would have to join in that deed. So it's a way of the parent can convey the title to their children, but kind of still supervise what's going on with the property. And that's a lot of what we see there. The way that you can terminate a life estate is upon the death, so you record a death certificate, or the life tenant can convey their interest at any time they want. So if we have a fee simple title holder with a life tenant and the life tenant conveys their interest in the quitclaim deed, regardless of if it says this is my life estate interest, a quitclaim deed conveys any interest that they have. So whatever they have, they've conveyed. So they had a life estate and they did a quitclaim deed back to the fee simple owner that relinquishes the life estate. There are other life estates. An enhanced life estate is where a grantor will convey the property to themselves and then to a remainderman. So the remainderman will get a future interest when they die. But in order to properly vest in an enhanced life estate, they must have language in the deed that says that they retain the power to convey or sell or mortgage the property. So it's another estate planning tool for them to set up in a deed that Kevin's going to be my remainderman. I retain the right to convey the title, to mortgage the property. So Kevin doesn't get an interest until I die. So for the sake of a transaction with us, a refinance transaction, the remainderman has no interest. It's a future interest. It's an estate planning tool. So if we were going to refinance, I would only have to sign. Kevin's my remainderman. He does not need to join in any document as he does not have an interest at this point. Now, lenders do have an issue with that as they do with life tenants. So typically they will not lend on property that is held in an enhanced life estate. The way that conveys title, like I said earlier, a death certificate can convey title. If there's an enhanced life estate deed on the property, when the grantor dies, you record the death certificate and that conveys title to the remainderman. Okay. There's also an interest called a leasehold. So the title holder doesn't own the land. They lease the land. So the instrument is not a deed that conveys title, it's an assignment because there's a lease agreement on record. So you're assigning the lease to a new owner. You would own the home on the property, but you rent the land. And typically it's annually or semi-annually ground rent. So there's a lease agreement on record that says that you have to pay $125 semi-annually to the landlord. That's the agreement. For the purposes of our transaction, we need to make sure that the lease agreement lives for as long as the mortgage lives. So we don't want the lease agreement to terminate next year. We want to make sure it goes at least 30 years for the life of our mortgage. That makes sense?
Mm-hmm. So who's responsible for taxes on the land? So the landlord would pay taxes on the land.
No, the homeowner will pay taxes to the landlord. So the landlord owns the land.
Right. Yep.
And the homeowner will pay taxes to the landlord.
Well, right. So, but if the landlord doesn't pay the taxes to the county.
Oh, I'm sorry, the taxes.
Yeah. It was just more of a
homeowner. Yeah, the homeowner.
Does the homeowner pay like the full like city, county, what have you taxes so that the land can't be like.
Typically they do, yes. Yep. Now you can convert a leasehold to fee simple. We've seen that happen before. A lot of these are in Maryland. And these Maryland lease agreements are good for 99 years and they automatically renew. That's the majority of what we see. And we've also seen where the landlord will convey with a warranty deed to the homeowner, and that converts the property out of the leasehold. So tenancy, while vesting is who holds title, tenancy is how they hold title. And this is important, especially when someone dies, when we have a deceased title holder. So individual is a sole owner. One person holds title alone. Upon their death, their estate needs to be probated. There's nobody else on title. It's just them. So if they have a will, their will will be submitted to the probate court. Probate court will look at the will, determine validity of the will, and see who the heirs are of the property, who they left the property to. So the whole probate process would start. That's individual. So there are a few types of co-ownerships. Did anyone get those on the assessment? Chris? What'd you get?
I got, tenants by the entirety,
Yep.
tenants in common, and joint tenants.
You got it. All right, so tenants in common. Upon the death of one owner, their percentage goes to their heirs, not the surviving tenants. So you have 3 people on title and they hold in tenants in common. They each have a third interest if it's not specifically stated otherwise. The person who dies, their 1/3 interest will go to their heirs. So it's not a survivorship. All right. Each person that's on title can convey their interest. All right. So if Michelle and I own title as tenants in common, I can convey title to Carl, and then Michelle and Carl own the property. Okay. It doesn't need to be equal. I can own 80% and Michelle can own 20%. It has to be specifically stated on the deed. If it's not stated on the deed, it's equal. We can acquire interest at different times. It doesn't have to be in the same deed. So I can own property and convey 50% to Chris, and then I can convey 50% to Kat. So the full vesting for that property is by 2 deeds. If tenancy is silent, so if the deed is conveyed to Chris and Kat and it doesn't say anything, it defaults to tenants in common. You have to specifically state otherwise. Okay. Now, joint tenants with rights to survivorship. So this is when the survivors receive the full property. So Michelle and I own property as joint tenants with rights to survivorship. If I die, Michelle automatically gets it. She's the survivor. In order for this to work, we have to obtain the property at the same time by the same deed. Okay, so my example where I conveyed 50% to Chris and then 50% to Kat, they can't own joint tenants with rights to survivorship. So that's 2 deeds, and they haven't agreed to hold that way. So I would have to convey to Chris and Kat at the same time and state in the deed that they want to hold as joint tenants with rights to survivorship. Now, if Chris and Kat hold title together as survivorship, if one of them conveys their interest, so Chris conveys 50% to Michelle, that severs the tenancy, because now you have vesting by multiple deeds. It severs the tenancy. So now Michelle and Kat hold as tenants in common. Okay, so the full vesting must be by the same deed. Tenants by the entirety is for who? Married couple. It's called entirety because a married couple is considered to be one entity. So it's not held by Chris and Natalie, it's held by the marriage. Their marriage is the entity that holds the property. Now, tenants by the entirety is a survivorship ownership. So when one spouse dies, the other spouse that survives automatically gets full ownership. Dissolution of marriage severs the tenancy. So when a married couple gets divorced, it automatically converts to tenants in common. Okay. So if you just got divorced and you hold title with your spouse and you die, you don't want your spouse to get your property. You want your heirs to get your portion of the property.
So once the divorce has been recorded, you don't actually need to do a deed. So say, we're married and we're both staying on title, but we're divorced. It's no longer by entirety. So at that point, if I were to die,
It
My 50%
automatically
would be-
converts.
Gotcha.
Yep. So it's very important that when we have a married couple on title and one of them is deceased, when we get the death certificate, we must look at the marital status and make sure that when they died, they were still married to the person that they held title to. Right? So we know that the title automatically goes to the surviving spouse. Not all states recognize T by E. Some states you have to specifically say we want to hold tenants by the entirety. Some states it's presumed, and it can go two different ways. So some states say Chris and Natalie hold title, they don't say anything. However, they are in fact married when they took title, so the intention is tenants by the entirety. Some states say, yes, you don't have to say tenants by the entirety on the deed, but you have to say husband and wife on the deed, or a married couple. So if it's silent, we have to look at the laws of that state and see if it's a presumption for tenants by the entirety. Okay. All right, so let's talk about some liens. What's a voluntary lien? Mortgage, a deed of trust. Okay, how about an involuntary lien?
Tax liens.
Pretty
Tax
much everything
liens.
else.
Everything else, judgment. Yep, UCC, federal tax liens, judgments. Okay,
The UCC is an involuntary?
well, that's a voluntary lien. And I kind of laugh at this because I feel like all of them are voluntary. If you don't pay your taxes, you kind of chose not to do that. Statute of limitations. It's the amount of time a creditor has to enforce a lien. Okay? So when we underwrite our files, anything that we see in the title search, if there's a judgment that is filed against our borrower, every state has a statute of limitations, and it also depends on the type of lien. So in Pennsylvania, if you have a state court judgment that's, a credit card, then, the statute is 5 years. So when you file the judgment, you have 5 years to enforce it. After the 5 years is up, it's expired. So your mortgage, you have ancient mortgage statutes too. So you have a maturity date on your mortgage. And then each state has their own statute as to when that mortgage actually expires. Okay, so some states will say that after maturity, your mortgage will expire 5 years from then, 10 years from then. It goes up to 20 years. In New York, it goes up to 80 years. So it depends on the state. So we like to see those older mortgages where they have a maturity date listed on the mortgage and the statute is up. We can ignore those mortgages. They're expired per statute. Does that make sense?
So does that happen a lot of like a release that never recorded?
Yep.
So then you just clear it.
Mm-hmm.
Do you have a list
If
of
it's
these
old
statutes?
enough, we do. I'll provide that in the next training. So it depends on what it is. Condo liens have a different statute than state court liens. Federal tax liens are 10 years from the date of assessment. Everything has a different time frame. Lien priority is the chronological order of recordation. First lien on record is first priority. Subordination agreements can switch lien priority. So a lender will agree to waive their priority. Okay, so what we mean by waiving the priority, we're doing a refinance now and we have a first mortgage that we're refinancing and they have an existing second HELOC on title. The new mortgage lender wants to be in first lien position. It's a first lien mortgage. The existing second lien holder will waive their priority, meaning that once we pay off the existing first mortgage, that existing second mortgage moves up into first position. Okay, so we want them to execute a subordination agreement saying that they currently are in second lien position. The borrower is refinancing, paying off their first mortgage. They agreed to subordinate their interest as if the first mortgage was taken out before them, the new first mortgage. So they're agreeing to remain in their second lien position. So they're currently in second lien position. Subordination agreements, the process is very time consuming and they ask for a lot of documents. The reason why they do this is they have to re-underwrite their loan. So while they gave a second mortgage to someone years ago, they have to take a look at the file and make sure that the property still has enough equity to be able to hold that second lien position. They also want to see our 1003 to make sure that they know what the new loan amount is. If they're in second lien position to a $100,000 mortgage, and now we're asking them to be in second position after a $200,000 mortgage, that changes their position. So they really need to look at the file and look at all of the facts to determine we will still have equity in the home to be able to be in second lien position. So it is time consuming and we kind of think it's easy. Well, you're already in second position now, just sign it and you'll still be in second position, but they have to look at all the facts, the new loan amounts, the equity in the home. So you'll see them ask for an appraisal and look at the 1003 and all of those documentations. So it is, and it takes time. It takes, a couple of weeks, 2-3 weeks. So it is a process. A modification agreement is when a lender and a borrower agree to modify terms of an existing lien. They can increase or decrease the loan amount. We see this a lot with home equity lines of credit, where they want to increase the line amount, or we've seen it where you decrease the line amount. That happened a lot in 2007 to 2009 when property values tanked and properties did not have enough equity to hold a line amount. So they either froze them or decreased the limit. You can also do it for other reasons, to revise terms of the loan, interest rates, extend the maturity date, anything to that nature.
Is this what a SEMA would be, or is that totally different?
Yeah. A SEMA does that. A SEMA is a consolidation extension modification agreement, so it consolidates two mortgages. So in New York, where a SEMA is available, you'll have an existing mortgage, and someone who wants to refinance and get a little bit more cash out would take just a gap mortgage. So if you have a $100,000 mortgage and you want to refinance for $150,000, your little gap mortgage would be what is taxed. So in New York, that's the way to get around the mortgage tax, because it's so expensive in New York to record a new mortgage. If you do a consolidation of an existing mortgage, the borrower is only taxed on the new money that they take out. Judgment. So a creditor can record a lien in the county. The judgment will attach to any property that the debtor owns in that county. So if they own 3 homes in Providence, attaches to all 3 homes. Okay, they only have to pay it once. Depending on the state, an existing judgment may or may not attach to after acquired property. So you may have a judgment that is filed in a county where the debtor doesn't own property. Doesn't attach to anything. Once that debtor acquires property, there are some states that say that judgment is going to attach to your new property. And there are some states that say, no, it's not going to. There is a tenants by the entirety protection. So this says that a judgment against one spouse does not attach to the property that's owned by tenants by the entirety. This goes back to tenants by the entirety, meaning that the property is held by the marriage. So they don't want to attach a lien against the marriage where one spouse is, the debtor. So it's really protecting the non-debtor spouse.
Is that why you have a CMA signed at closing for the judgment?
Yeah. Yep. We have a CMA, a continuous marriage affidavit that we have signed for death. So that's going back to tenants by the entirety severance. So if you have one spouse that dies, we make sure that they're still married on a death certificate, and we have them sign the continuous marriage affidavit for our file. So they're stating, yes, we took title together as a married couple, and we're still married at the time of the death. The CMA for the judgment says the same thing, but it's not pursuant to death. It just says that there's a judgment out there. I'm married to, we're married and we're still married, so the judgment doesn't attach. It's protected. Now, there is one state that says if there's a dissolution of marriage and there's a judgment against one debtor, once that tenants by the entirety severs, that existing judgment will attach to the property. Now the timing is what matters here. So Pennsylvania says that the judgment will attach as to the initial filing of that judgment. Okay. So if a spouse has a judgment from 2007 and they divorce in 2010, the judgment attaches in 2007. So if they refinanced in 2009, that judgment is ahead of that 2009 mortgage. So because of that, we have to pay all Pennsylvania judgments. We can't use the protection because we can't predict what's going to happen in the future. So we need to make sure we secure the lender's lien position. So if we're doing a refinance today and there's an existing judgment against one spouse, we satisfy the judgment because we can't predict if they're going to get divorced next year. That judgment would be ahead of our new mortgage. So in order for us to issue that title policy and ensure the lien position to the lender, we need to satisfy that judgment. So Pennsylvania is the only state that does that. So Pennsylvania, we never use the T/E protection. All other states take the position that once the tenants by the entirety is severed, that is when the judgment attaches. So that 2007 judgment would attach at the time of the divorce. So it would be in the future. So it would be after our new mortgage. So those states, all the other states, we do use the tenants by the entirety protection. And this is only for state court judgments, okay? So it does not include IRS tax liens. It's only for those civil judgments.
Doesn't child support judgments supersede everything too? They're kind of like the IRS ones.
Child support, well, it depends on what they are. It depends on if there's a judgment that is listed in the divorce decree, then it can supersede that way.
I just mean like those ones need to be paid no matter what, right? They're kind of like the IRS ones.
You can't avoid them.
Yeah, there's no way around.
Right, there's no protection around them. Yep.
Yeah, that was like the first third of that judgment search.
Oh, your judgment search for Jose Rodriguez? Yeah. All right, so bankruptcy. once bankruptcy is filed, all real property that's scheduled by the debtor becomes the property of the bankruptcy court. So the debtor files a petition in the bankruptcy court and they list all of their assets. They list all of their personal assets. They'll list money that they have in their bank accounts. They'll list the clothing that they have, furniture, jewelry, automobiles. I've seen tractors, guns, dogs, all the personal property and all their real property that they own is listed as assets. So they have to disclose all of that to the bankruptcy court. Now, so once that is all disclosed to the bankruptcy court, they can't just do whatever they want with real property. They can't sell it or mortgage the property. It needs to go through the bankruptcy court for approval. Okay. When they file bankruptcy, the automatic stay happens. This is when all of the creditors are notified that the debtor filed bankruptcy, and they can no longer harass that debtor to pay the bills. So no phone calls, no sending payoff statements. They have to, it's called the automatic stay. They stop. They can't do anything. They cannot collect on the debt. Okay. In order for a borrower to refinance, the case needs to be terminated. All right, so there's a long process with the bankruptcy case. The debtor will be discharged, and then a few days later, the termination will come through. So we need to make sure that it's terminated. In some cases, we can close on our refinance if a motion to refinance was filed and the court granted that order. You'll see that in a Chapter 13 case. So Chapter 13 is reorganizing your debt, and they do a payment plan, which is typically 5 years. It's 3 to 5. You typically see the 60-month payment plan where the debtor will pay a monthly amount to the trustee, and the trustee will distribute funds to their creditors, percentage to each creditor. And it helps the debtor reorganize their debt, paying it off little by little. Okay. If we had the order granting a motion to refinance the property and it was a Chapter 13 case, we would have to call the trustee and obtain a payoff for the plan if it hasn't been completed yet. And then they're very specific on the terms. So when you file a motion to refinance, you'd have to send in your 1003. You can't change the terms. So once they approve that order for you to refinance at this loan amount, at this interest rate, you can't change those terms. Otherwise, you have to go through the process all over again. And they're very strict with how to follow their process. Once you close, you have to submit the signed CD and other documentation to the bankruptcy court within a certain amount of time. It's like 48 hours. They don't give you a lot of time. Okay.
Now, do we do that, or does the lender do that?
We would do that.
Okay.
Mm-hmm. Okay. You'll hear this a lot. It was discharged in bankruptcy. The borrower gets so upset. So we run the search. We see a judgment that is attaching to the property. And you call the borrower and they say, I went through bankruptcy and I was discharged. Okay. So when the bankruptcy case is discharged, it serves as a discharge to the personal liability. So they're not personally obligated anymore to pay this. But if it was a lien, then the lien is still active. All right. So it's only the discharge of the bankruptcy is just your personal obligation. All right. If it exists as a lien on property, it has to be satisfied in a refinance or a purchase. So this is why the debtors don't realize it until they go to refinance their property or sell their property, and Equity Title calls them up and says, we need to pay this judgment. They don't typically know or foresee that happening. bankruptcy attorneys, and they may not have a bankruptcy attorney, but what typically a bankruptcy attorney doesn't do a title search. So they don't know of judgments and liens unless the debtor tells them that we have a lien. And sometimes the debtor doesn't realize that they actually have a lien. They know that they have this debt out there and they don't realize, oh, it's a lien on my property. So they don't know to tell the bankruptcy attorney or to disclose it as a lien. And a lot of times we'll see on the petition that the lien that we see in land records, they disclosed as an unsecured debt. So the attorney and the bankruptcy court will see it as an unsecured debt. If they go through the process properly, you can avoid a judgment. And that is with filing a motion to avoid. So you file a motion to avoid with the court saying that you have a specific lien and you want to avoid it. The court will grant the motion or not. Typically they do. And that's what avoids the lien. So in order to avoid a lien in bankruptcy, the motion to avoid has to be filed and granted. Okay? You can, Chris. So that's an option. So we've done that before where if it's a substantial amount of money. So you can reopen a bankruptcy case and file a motion to avoid. It will take a little bit of time and money, but if you have a substantial judgment, $30,000 judgment, then go ahead. It makes sense to do it that way if you have the time and to be able to do that. Or if it's, just a small balance, some people will just pay it off. The borrower always has the right to call up the creditor and negotiate a payoff. And they'll say, I filed bankruptcy and I scheduled this debt in my bankruptcy. Now I have an issue with my property and, there's a $2,000 balance on the debt. Let's settle for $1,000. I'll pay you $1,000 and you'll release it for me. So they can always make a settlement. We can't, as a title company, we don't represent the borrower as an attorney, but the borrower can go ahead and do that. If we were to obtain a payoff, we would get the full payoff.
Right. So if they send us the payoff of the agreement, that gets written on the CD and is paid as part of the transaction.
And yep. So those settlements are also very specific where they have time constraints on them. So if the creditor says, I'm settling this debt for $1,000 and this is good through May 1, we have to have that money in their office by May 1. Otherwise, that agreement is null and void. If we pay that on May 2, they can come back and say, well, the settlement's now void and I want another $500.
If a motion to avoid is granted, is something recorded?
It's filed in the bankruptcy court.
Okay.
The best practice is to get a certified copy of the grant motion to avoid and record that in land records.
Okay. So how would the borrower know that they were granted a motion to avoid? Like how would you kind of discover that?
Maybe.
Yeah.
But during our underwriting process, we check bankruptcy on every borrower and every title holder.
Okay.
So we need to make sure that bankruptcy is not open for us to move forward in our transaction. So we're always checking bankruptcy.
Okay.
If there are judgments that come up and we notice that there was a prior bankruptcy, the underwriter will look at the prior bankruptcy. It's all online. It's public record.
Okay.
And they'll search for a motion to avoid. So they'll get that information right away. So they'll make a curative for the title curative coordinator and say this judgment is opened. They had a prior bankruptcy, but it wasn't avoided. So we need to satisfy it.
Okay. I have a question on the settlement. So if that check were to get to the debtor on date, like May 2nd, they're going to remain in first lien position until the borrower then pays the remainder of the balance, correct?
Mm-hmm. Yeah. Yep. So anytime we get an agreement like that, we make sure that we get an updated one. So we need an agreement that is dated, that's good through our closing and disbursement date and enough time to get the money there.
similar
So
to
if
any
we're
other
like
thing
in
on
a
Reddit
time
where we've had it.
constraint, we would ask for wiring instructions or an updated payoff.
Settlements usually don't have per diems on them. It's usually like this
Well, no,
is
just
like
a
by the
date.
date,
Yeah,
yeah,
I
by the
bet
date,
like
yeah.
you would want to like have them request a settlement
Right.
through like a padded
Right.
date.
Yep.
Mhm.
Yeah.
Exactly.
Definitely.
Yep. We want to cover through our disbursement. Yep. And if we're coming close to a time constraint like that, we would make sure that we are communicating with disbursements, like we need to FedEx this right away, or we need to get wiring instructions and wire it. This is high priority. That needs to go out. Okay. Good on bankruptcy? Bankruptcy's fun. Oh no, I had another slide on bankruptcy. Sorry, I just wanted to,
So we're not good on it?
we're not good on bankruptcy, but I wanted you guys to know that there are some liens that can never be avoided. And those are tax liens, student loans, domestic support, and criminal restitution and reaffirmed debt.
What's reaffirmed, Dad?
That the lender reaffirms the debt, so they are saying that the debt is still in existence. They're reaffirming it, and they're moving forward with enforcing the debt and the lien. Okay.
So basically, if you're trying to do a motion, to avoid, and the lender is just like no, then is that like what you mean?
Usually you see it in the context of a mortgage,
Oh, okay.
a mortgage or a home equity line of credit.
So what does this mean? This just means we have to collect these on the CD? Or what?
The-
What does this mean?
the-
Like these
The liens that
that
can't,
cannot be avoided.
what can't be avoided. So it just means that like if you have a bunch of student loans, you can't file bankruptcy and think that they're all going to go away. You can't get rid of student loans. You can't avoid tax liens by filing bankruptcy. So that debt is still going to survive bankruptcy. Okay. So a fiduciary means that it's a person acting on behalf of someone else. So an executor or an executrix, that's someone who is signing on behalf of an estate. So an executor is a male, an executrix is a female. A guardian is someone who is acting on behalf of someone who is incompetent or underage. A trustee acts on behalf of the trust. So it just means that it's someone acting on behalf of someone else. And so that leads me to power of attorney. Power of attorney is just that. It's someone acting on behalf of somebody else. These are very, 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 very risky for us. So a POA has to include the authority to sign a mortgage for a real estate transaction. Or if you're dealing with a purchase, they have to state that they're giving the power to convey property. Okay. Why are they very risky for us? Any ideas?
Because the actual signer is not signing.
Yes. Yeah.
It doesn't grant power to convey.
Where is that person? Do they know about this transaction?
Because it could be fraudulent.
It could be fraudulent. Okay. So we could have a transaction where one spouse isn't going to be there. The other spouse says, I have POA over them. Okay. So what if they're pending divorce? Do you think that person wants them signing for them? No. What if they're dead? You can't sign on behalf of a dead person. We don't know. All we're seeing is a POA and someone saying, I have power of attorney over this person, so I'm going to sign. Okay? We always want to have a conversation with the person who's not available. Okay, the principal. The principal is the person who is appointing the attorney. So we want to talk to the principal. Do you know that so-and-so is in the process of this transaction and they're refinancing the property and they're using a POA to sign for you? Always want to be able to talk to them. We want to make sure that they are aware of the transaction and that someone is using the POA.
What
Okay.
about if there's and this is for a purchase, if there's a seller's attorney and say the sellers live, all over the place. Like I have one now where the sellers all sign the deed themselves, so there are 4 sellers. I received a POA yesterday for one of the sellers to sign the remaining documents for the other 3, but all of them physically signed the deed.
That is perfect.
Okay.
That's perfect. So we always, if possible, want the person to sign the deed. That's the document that is conveying the property. That's where all the risk is. So if it's a situation where it's, location driven, where they just can't get to the closing and we're unable to do a split closing, absolutely have them sign the deed. We can send a notary or an attorney anywhere that they are to have them sign the deed. Especially if we need them to sign a new POA, send the deed with it. Have them sign the deed and the POA together, and then the rest of the closing documents will be signed by the attorney in fact. But absolutely, we always have the deed signed whenever possible. We have the actual person sign the deed. Okay, so there was a question on your assessment. If someone was incompetent, where was it? If a person is not competent, is it okay to have them sign a power of attorney to give authority to have someone else sign for them?
No.
No, they're not competent. They can't sign a document. Good. All right, so all powers of attorneys that come through our office, we escalate to an underwriter or myself or Ben for approval.
So what if there's nothing in the power of attorney that talks about cash out? Like if it's a cash out loan? Like right now I have a live well that's going to need a POA, but it's Washington State and FNX is going to insure what the borrower is getting back, like $11,000.
Yeah, so in that case, FNAS needs to approve it. They're insuring the loan.
Do we have like in-house rules on like what we can approve as far as like the cash out amounts go? If nothing was indicated on the POA?
No, we don't have standards on that. It's kind of, we take it as case by case basis. So if we have a case where we're able to talk to the principal and they're completely aware of the transaction and they're alive and well, they're just, out of the country or something like that, then we feel comfortable with that. All right, there are some situations where there are a bunch of red flags where someone makes it very difficult or, makes it seem like they don't want us talking to the principal and making sure that they're aware of the transaction. That would be a red flag that we wouldn't want to use the POA for a transaction where they're cashing out $50,000, something to that effect.
Well, on this file, the doctor's note said that she was like fine to sign documents, and then there was another doctor's note like 2 days later saying that she wasn't.
Yeah, that's a red flag. That's definitely.
FNAS, so it's up to FNAS, right?
It's up to whoever's insuring the transaction. But we would want to.
Do we like ethically not do?
Well, we would want to advise our lender of what's happening so we can all make the right decision. That's why it's very risky. It's extremely risky. So at all costs, make sure that we have the person signing. So the very first question that you ask